Dumelani sanibonani ninjani molweni avusheni thobelanda. Guys, today we have a CIV and on the other side we have assignment. Let me try to zoom. We have assignment, so I will not answer assignment question number 1 or question number 3. I will answer them on that other one that you know, the payment one. The payment one. So we'll start with the question number 2. J and T are married to each other and are domiciled in Pretoria, in Lesotho. The thing that you must know is that they are domiciling in Lesotho. And then after having been married to each other for a period of 8 years, J wishes to divorce his wife T. At the time of the institution of the divorce proceedings, J had been living in Pretoria for 10 months. It's very much important to note down 10 months. 10 months. 10 months. With these facts in mind, answer the following questions. Give full answer for your question answer. Will the Pretoria High Court have a jurisdiction to hear the action for divorce? 3 marks. Will the Higher Pretoria remember? J had been living in Pretoria for 10 months. And remember, T lives in a domicile where? In Lesotho. So, in order to know about the Domicile Act, it means that you must have a Domicile Act. However, you must know that in order to read this and understand, you must have a Divorce Act. On the other side, you must also have a Domicile Act 3 of 1992, which can make you to know about the domicile thing. So you will definitely have to go in that question, you will definitely go to section 2. Section 2 talks about the jurisdiction, and then you will say section 2, subsection 1, paragraph B. They said a court shall have a jurisdiction in a divorce action if the parties are if are or either of the parties is domiciled in the area of jurisdiction of the court on the date on which the auction is instituted, or ordinarily resident in the area of jurisdiction of the court of the said date, and have or has been ordinarily resident in the Republic for a period of not less than 1 year. Not less than 1 year. Immediately prior to that date. So it means that this is also talking about the person who's from outside, saying that if you are here, you must be here for a period of not less than 1 year. So now, as a result of that, we can conclude and go and answer the question. It means when you answer, you'll say the basic common rule principle regarding divorce jurisdiction is that the court of the common law domicile of the parties have jurisdiction to hear an action for divorce. Section 2(1), paragraph B of the Divorce Act provides that a court is competent to exercise divorce jurisdiction if one of the parties to a marriage is ordinarily resident in its area of jurisdiction at the time of the institution of the action, and that this party has been ordinarily resident in that republic for not less than 1 year prior to the institution of the action. In terms of the given facts, J is not ordinarily resident in Pretoria since he has been ordinarily resident there for a period of less than 1 year. J has 10 months in Pretoria. Accordingly, the High Court Pretoria is not competent to exercise jurisdiction in terms of the Section 2(1)B to hear J's action. So it means that J must wait until a period of over a year and then institute a divorce. So he must wait a bit, another month, so that he can be able to institute a divorce action. This was the number 1, how to answer it, and let's go to number B. Number B, if J decides to issue summons against T, explain how the summons will be saved on T, who remained in Lesotho. You must know that the sermon is saved in three ways: normally, substitute service, and a dictal citation. And we go straight to a dictal citation. The respective rules of court, which is based on Rule Uniform 5 or Rule 10 of Magistrate, prescribe how service must be effected on a defendant who is or believed to be outside of the Republic. This is so even when his or her exact whereabouts are known, and even when a person's service is possible, such a person cannot be summoned before a court in any manner other than by means of a dictal citation. This means that when you answer, you will say edictal citation. It is based on Rule 5, which prescribe how service must be if affected on a defendant who is or believed to be outside the Republic. This is so even when his exact whereabouts are known and even when a personal service is possible. Such a person cannot be summoned before a court in any manner other than means of edictal citations. Don't forget that the video contains a well-researched educational information. Unfortunately, we cannot share all information public. This is in line with the African indigenous law of nothing for mahara. The full video are available on our channel for 100 Rand fee monthly. 100 Rand fee monthly allows you to watch all assignments videos. Once you pay our fee, it means you're eligible to request documents used in this video and other videos as well. If you don't see a video on our 100 Rand fee, please let us know on our WhatsApp 061 984 2135. Thanks for watching.